Good morning, Counsel.
Good morning, sir.
How can I help you?
Okay, may I please the honor, sir? I would like to submit an application of bad character of a witness.
Okay, who is the witness?
The witness in this case is Mr. David Parker, and if I may have the court's permission to proceed with my submission.
Okay, so which piece of the evidence of Mr. David Parker that you would like to adduce?
In essence, it would be the fact that he was in possession of a dangerous weapon, which is a kitchen knife, as well as evidence which had been missing when he was first asked by the police in terms of his denim jacket, and also his questions, his inconsistent responses to questions that had been put to him on 2 occasions, both when the knife was first found and later when he was questioned in relation to this case.
So which means in action is the knife that he was holding?
That's correct, sir.
Okay, you may proceed, Counsel.
Thank you, sir. Okay. May it please your honor, I'm Ronald Waits, appearing on behalf of the defendant, Mr. Duncan Moore, who had been charged, as you know, with one count of committing an offense of murder under the Criminal Justice Act, under the Homicide Act 1957, of which is punishable of the same. Now, I want to introduce evidence of bad character of witness Mr. David Parker on available grounds of the Criminal Justice Act 2003. I appreciate that, as a general rule, the admission of bad character of a non-defendant is inadmissible, but the court would also understand that there are exceptions that can be granted through 3 gateways available in Section 100 of the Criminal Justice Act 2003. Now, I'll first point out that bad character evidence, as provided in Section 98 of the Criminal Justice Act, purports evidence of or disposition towards misconduct of the person, and that it is evidence that is not in relation to the case in question or the alleged facts of the case in question, and also that it is evidence of not evidence of misconduct in connection with the investigation or the prosecution of the offense. Misconduct is further defined in Section 112, subsection 1, as being the commission of an offense or of other reprehensible behavior. Now, putting all these definitions in relation to the current case, I will put forward that Mr. David Parker, who had been with my client at the time when the victim, Mr. Simon Chapman, had been fatally stabbed with a knife on the left side of his chest, whilst he was severely beating my client, who was pinned beneath him, has clearly demonstrated misbehavior on the part of David Parker. Now, I'll go on to present that Mr. David's own admission, just 3 months before this incident, at a random locker check in his school, where a knife with a 3-inch blade had been found in his locker. And by Mr. David's own admission, he confessed, after several denials in the first place, to having placed the knife there for purpose of his protection against what he calls bullies in the school. It is my role, therefore, to submit to the court this evidence as being evidence of bad character on the part of Mr. David Parker.
Okay, Counsel, so now are you suggesting that Mr. Parker was holding the knife in the past constitute a bad character?
That is certainly evidence that is because of the similarity to the present case that it would constitute evidence of bad character.
Okay, sure, no problem. But you're also aware that the general bad character is not admissible in the court, right?
Yes, and I will go on today to explain why in this particular case the leave for admission of bad evidence character should be granted.
Yes, you may proceed, please,
yes,
Counsel.
Thank you, sir. Surely it is not normal or of good character for someone to be bringing a knife to school and holding it there. There is this possession of dangerous weapon, which is clear evidence of misconduct or poor behavior, and also the fact that the evidence is relevant and of probative value to the present case because of its similarity. And we also cannot discount the fact that the knife could be the very weapon that had been used on the victim, and that David had demonstrated a propensity that he is capable of such an act.
So, Counsel, can you direct me which statutory provisions that govern this area of law, please?
Okay. That would be in Section 100, subsection 1, okay, subsection A, where it was clarified that such evidence would be important to explain the evidence, further evidence of the case, that without which the judge or the jury would have difficulties in understanding other evidence of the case, and also that it adds value to understanding the context of the case as a whole.
So, Counsel, so can you explain to the court that why this piece of evidence is so important to the case?
In essence, the very fact that he has the propensity or the capability to use a weapon, a dangerous weapon, is clearly demonstrating of his behavior, and the fact that he was present at the time of the incident along with my client raises the question of whether it could be the witness himself who has committed such an offense. So it is of vital importance to my client in this case that defense be given the right to utilize this bad evidence character and also to cross-examine the candidate, the witness at that time.
Okay.
Thank you. Now, the first gateway, as I explained, is pursuant to Section 100, subsection 1A, where it's clarified that in Section 102 also the evidence is being evidence which is important and of explanatory value. This was also raised in the case of R versus Davis in 2008, where it has been held that such evidence is intended to explain and not to contradict the case, and which is what I am presenting here in this case as well. Now, the second gateway is pursuant to Section 100, subsection 1B, which refers to substantive probative value, which identifies factors to be considered as defined in Section 100, subsection 3. It is clear that the nature and proximity of value of the time when David was in possession of the knife is of substantial importance to this present case, okay, because of the similarity of the conduct as well as the offense of the present case. It raises substantive probative value of such misconduct. It also raises the credibility of the witness in view of his poor behavior. The witness' questionable credibility can be further evidenced by the inconsistent responses which he had given when he was first questioned about the knife in his possession in the locker, and also when he was questioned by the police for this case. The mystery over the missing denim jacket when the police first asked for evidence was also would also question the credibility of Mr. David Parker in terms of his truthfulness. Based on the facts, I submit that to the court that the bad character of David Parker is relevant, and without which the result of this trial could be unsafe for my client. I would also like to rely on the authority that was given in the case of Regina versus Brewster and another in 2010, where the Court of Appeal of Lady Judge Pitchford and Judges Madison and Maddow allowed an appeal on the defendants, allowed the evidence of bad character of an anonymous witness to the case. In that particular case, it was held that the word substantive probative value in the context of Section 100, subsection 1B, did not require the applicant to establish that the bad character relied on amounted to proof of lack of credibility of the witness when credibility was an issue of substantial importance, or that the convictions demonstrated a tendency for untruthfulness.
So in short, counsel, what is the relevancy of you citing this case?
Okay, in this particular case, it was held that the more important question is whether the evidence of previous convictions or bad behavior was sufficiently persuasive, okay, to worthy consideration by a fair-minded tribunal, okay, such that they would be able to see for themselves and determine the creditworthiness of the witness. The conviction did not, okay, to qualify for admission evidence, have to demonstrate any tendency towards dishonesty or untruthfulness itself. Okay, so once it has been decided that the conviction is of substantial probative value in relation to the issue of substantial importance in the context of a case as a whole, then there is no residual discretion except in the case or in the exercise of case management to refuse such evidence or such admission of evidence.
Okay.
So in summary, I would just like to say that in view that leave is required from the court, I will humbly request Your Honour to grant admission of the bad evidence of Mr. David Parker on the grounds of Section 101A and 101B, as well as authorities which I have cited in earlier cases today. Thank you, sir. If there are other questions, I'll be happy to address them.
No, thank you. Thank you, Counsel.